If you've lost a loved one in unexpected or traumatic circumstances, the last thing you want to think about is how to conduct your case at a coroner's inquest. But that is something you may be forced to prepare for. It's not easy to get a lawyer to represent you at an inquest. Funding is generally not available, and many families now have to face conducting inquests by themselves. There is help out there. Have a look at the website of an organisation called Inquest. It's excellent. If you're a bereaved family, they'll provide you with a very helpful guide for free. I'm a QC, and for 25 years I've been representing families at inquests with a particular focus on deaths of patients who've been in hospital or have been cared for in the community. In this film, I want to add to the advice available by passing on my experience about a specific aspect of coroner's inquests: advocacy. How should you go about the task of questioning witnesses? What questions are you allowed to ask? What happens if an expert gives evidence? And what submissions can you make to the coroner? I'm going to give you some tips on advocacy based on my own experience, but first you need to know something about the role of the coroner and the procedures in the coroner's court. Coroners are appointed for specific geographical areas. They're very much the lords and ladies of their own courts. They decide what evidence should be called and in what order. They take a lead, asking the questions. Unless there's a jury involved, which is rare, they weigh up the evidence and they make findings and they return the verdict. So what role would you have? Well, coroners invite so-called interested parties to participate in the inquest. Interested parties can suggest what evidence the coroner should hear, they can ask questions of witnesses, and they can address the coroner on the law. Parties do not have the right to make submissions to a coroner on the facts of the case, on the evidence heard at an inquest. You can't make a speech trying to persuade a coroner to accept the evidence of one witness over another. But you can suggest that a certain verdict is appropriate. The deceased's family is an interested party. Other parties might include the NHS trust that was caring for the deceased person when they died, or even individual doctors or nurses. Although you may feel that you are against the other interested parties, an inquest is not what lawyers call an adversarial process. It's inquisitorial. In other words, no party has to prove or defend a case. The parties are there to assist the coroner to inquire into the death and to reach a verdict. If you feel that another party is being antagonistic or unfair, just tell the coroner. In cases that are not straightforward, a coroner will be likely to hold what's called a pre-inquest hearing. There you can address the coroner on what evidence ought to be heard and any specific arrangements for the main hearing. You need to think, therefore, about what evidence the coroner should be looking at. Try to persuade the coroner to obtain evidence from this doctor or that nurse. Make sure all the medical records have been made available. It often helps to write out the suggestions you have for a coroner at the pre-inquest review in advance. If you can, type them out, make several copies and try to send them to the coroner and the other interested parties before the day of the pre-inquest hearing. Take note that when making arrangements for the inquest hearing, the rules state that an inquest ought to be concluded within 6 months of the coroner being made aware of the death. Now, let's look at the inquest hearing itself. Typically, the coroner will have ensured that witnesses have provided written statements or depositions setting out their evidence prior to the hearing. If you were a witness, then you might have to give evidence and be questioned, as well as acting as an advocate. The coroner's officer or another appointed person will contact you about making a statement. If you haven't been asked to give evidence and you think you have relevant evidence to give, then let the coroner or his officer know. Witnesses will be called forward by the coroner. They will promise to tell the truth, the whole truth, and nothing but the truth. The coroner will then ask them questions designed to extract the evidence they've already put in writing. After the coroner has finished, he or she will turn to the interested parties and ask them if they have any questions. A little later, I shall give you some tips about asking questions, but first, here are 9 pieces of information you need to know. At hearings, you should address the coroner as Sir or Ma'am, depending on their gender. You can refer to the legal representatives of other interested parties by their names, Mr. Smith, Miss Jones. Usually you can sit down when asking questions and during the inquest generally. Just stand up when the coroner enters and leaves the hearing room. The inquest is held to find the answers to a limited number of questions, and they are: who was the deceased, and when, where and how they died. Some inquests are known as Article 2 inquests. This refers to Article 2 of the European Convention on Human Rights, the right to life. If the coroner is concerned that there might have been a breach of Article 2, then he or she ought to hold an inquest that makes a wider inquiry into the circumstances surrounding the death. A coroner is not permitted to ascribe blame for the death to any identified person. In relation to the question of how the deceased died, the main verdicts open to a coroner in a healthcare case are accident or misadventure, alcohol or drug-related death, unlawful killing, natural causes, an open verdict, stillbirth and suicide. Alternatively, a coroner might decide to give a narrative verdict. That's a short account of how the deceased died. A coroner must summon a jury in certain prescribed cases, including a death in prison or police custody. A coroner has a discretion to sit with a jury in other cases if there is, quote, sufficient reason, unquote, to do so. Inquests are held in public, so journalists and the general public are permitted to attend and to report on the proceedings. With that information in mind, let's look at some tips on how to act as an advocate at an inquest. I hope that these will help you on the day or the days of the hearing. If you feel in control of this side of things, then it should help the whole inquest process to feel more worthwhile and effective for you. At the heart of effective advocacy is preparation. You need to prepare in respect of witnesses, documentation and questioning. Give yourself plenty of time to prepare and give yourself plenty of time on the day of the hearing. Don't aim to arrive 10 minutes before the start, aim to be there at least an hour early. You won't want to feel rushed on such a big day. It seems obvious, but you need to know who's going to give evidence. So ask the coroner to provide you with a list of witnesses and copies of the statements they have made. If you think that there are other people who should be giving evidence who are not on the list, let the coroner know in good time before the hearing, perhaps at the pre-inquest hearing. You can write to the coroner if you need to. Explain who you think should give evidence and why. Don't leave it to the day of the inquest. Ask for a running order. In what order are the witnesses going to be called? Read through the witness evidence. If there's a witness for whom you have no questions, whose evidence you accept or agree, then let the coroner know. It may be that that witness doesn't have to be called to give evidence. Their statement could be read at the hearing. Write out a list of witnesses with a couple of notes on each one, such as nurse on late shift, and put it in a ring binder followed by all the statements in order, each separated by a divider or a sticky note. Just get yourself organised. If you have documents to which you want to refer, inform the coroner in advance of the hearing. Other parties are entitled to see them in advance too. Don't produce them like a rabbit out of the hat during your questioning of a witness. That may lead to the inquest being adjourned or taking longer than it would otherwise have taken. At an inquest involving the death of a patient, there will be medical records. You need to have copies of those before the hearing to allow you to prepare. There may be GP records, which tend to be computerized these days, correspondence between medical practitioners, ambulance records, A&E records, clinical records from the ward, including nursing notes. Look out as well for observation charts showing the temperature, blood pressure or neurological condition, fluid balance charts, reports on blood tests, scans and x-rays, reports on swabs or samples showing whether there was an infection. And there should be prescription records as well. Under Part 3 of the coroner's rules, relevant documentation ought normally to be disclosed to interested parties in advance of the hearing. Best practice is for the medical records to be paginated so that everyone has the same documents in the same order with the same page numbers. Usually the NHS trust involved will be asked to do that if you're not represented. If you're given the records as loose pages, then just take the time to put them in a ring binder and make sure they're in order. Make notes about the important documents. You can always use a search engine to find out what certain medical abbreviations within the notes mean. Again, if you think there are missing documents, just let the coroner know it, but in good time before the hearing. Before the day, write up a chronology with the dates and times that are relevant to the case you want to get across to the coroner, with page references to the documents and the statements. After the coroner has asked a witness questions, it's usual for the family to be given the first opportunity to ask further questions, and the party for whom the witness works goes last. If the witness is a member of your own family, then you can still ask them questions, but usually you would be the one to go last. You only get one chance to ask questions of a witness. There's no second bite at the cherry. Witnesses will often leave the building after they've given evidence. But if you have forgotten to ask something that you think is important, or some new evidence emerges and you want to ask a witness about it, ask the coroner to recall that witness and just explain why. So here are my tips about questioning witnesses. Identify your end goal. Is there a particular verdict or a particular feature of the events around the death that you want to bring out? If so, direct your questioning with that goal in mind. Keep the questioning relevant. Remember the questions that the coroner has to answer. Who, when, where and how. Questioning has to be relevant only to those questions. Don't stray too far into the past or too much into the general rather than the specific, unless it's obviously relevant to the case. Don't ask a question if you don't need to ask it. If you're content with the evidence a witness has given on an issue, and the evidence doesn't need exploring, then don't ask questions about it. If the coroner has already asked a question of the witness and you were satisfied with their reply, well, don't repeat the question. That would only give the witness a chance to change their evidence. The art of advocacy involves knowing when to say nothing at all. Be selective. Target those parts of the witness's evidence you want to explore. It is ineffective to question every line of a statement. So be selective. Identify how the witness fits into the overall picture. Is this a key witness at the heart of what went wrong, or a minor character in the drama? Who did they have dealings with? Is their evidence consistent with those other witnesses? Does it make sense when set alongside the documents and other evidence in the case? Be sure of the purpose of the question you're asking. You might question to challenge a witness. Do you accept that you're mistaken to say Dr. Smith saw John at 10:15? To clarify, you say Dr. Smith saw John at just after 10 o'clock. Was that only a minute or so after 10? Or to expand on the evidence. When Dr. Smith saw John at the time you say, he spent only 2 minutes with him, didn't he? When challenging a witness, ask yourself, are they lying or are they mistaken? Because your approach to questioning will depend on the assumption that you make. If you're putting an inconsistency to the witness, make sure you have a clear answer to the first question before putting the inconsistent evidence to them. Don't leave room for uncertainty. That'll allow the witness to wriggle out of an apparent inconsistency. Be courteous. Don't speak across a witness when they're answering a question. Wait for them to finish. Don't argue with them, and don't grandstand. Just put questions. Don't make statements. Always put a question. It's quite simple to end a statement with, "Isn't that true?" or "That's right, isn't it?" to make it into a question. Try to ask one question at a time. Witnesses and coroners can easily become confused if you ask several questions at once. And keep questions short. A series of short questions paints a clearer picture than one long rambling question. Write out your questions before you arrive at the hearing. Leave lots of room between the questions in your notebook so that you can add questions or change them as the case proceeds. When you're listening to the witness give evidence before you, or before it's your turn to ask questions, then have a notebook, a pen, a spare pen, a highlighter and some sticky notes with you. Draw a line down each page of your notebook, about 3/4 of the way across the page. You can note the evidence given to the left of the line and make any notes of questions or points arising on the right side of the line. If there's a key answer, highlight it. If the witness refers to a page in the documents that's important, put a sticky note on it with a word reminding you of that page and make a note in your notebook of when the witness referred to it. You can put leading questions. A leading question is one that suggests the answer. You can do that at an inquest. Don't worry about asking a stupid question. If you don't understand something, ask the question. It may be that if you do not understand something, then the coroner won't do either. Perhaps even the witness won't understand it, and their evidence to you will be revealing. So be brave. Remember that the coroner cannot attribute blame for the death. So you mustn't ask questions aimed at attributing blame to a particular person. That does not mean you can't use questions to explore what ought to have been done or what ought not to have been done. The circumstances of the death might include a failure to carry out a test or an examination or to make a diagnosis. But what you mustn't do is ask questions like, "It was you who killed him, doctor, wasn't it?" You might feel like saying that, but the coroner will not thank you. And it is the coroner whom you need to give the verdict you think is right. You need to keep the coroner on your side. A word about expert evidence. If an expert is to give evidence, you should have been given the report in advance of the hearing. They're giving opinion evidence, not evidence of fact. It isn't easy questioning experts, but if you are unhappy with their opinions, there are several ways to approach questioning them. They ought to have listed in the first place what evidence they've seen. Check that they have seen all the relevant documents and the witness evidence. If not, their conclusions might be based on incomplete evidence and therefore be undermined. Likewise, if they've not been present throughout the inquest and they've missed some of the relevant evidence at the hearing, or a witness has said something at the inquest that they hadn't known about when they wrote their report, ask whether that further evidence would have changed their conclusions. Try to think that through and, if appropriate, put it to them that they would have come to a different opinion if they'd known about that evidence. If they agree, then you have a new opinion. If they disagree, then ask why, when the facts have changed, their opinion hasn't changed. Check that they've got the facts right. Sometimes an expert will have misread an extract from the medical records, for example. Is that an error important enough to alter their opinion? It is legitimate to ask whether their opinion is based purely on their own experience, and if not, on what published papers or studies. Is it based on a hunch or on hard evidence? Is it speculative? Is it guesswork? If they're predicting that something would have happened had certain treatment been given, then ask how certain they are of that prediction. Would the outcome they predict have been probable or only possible? Explore whether there might have been a range of views that experts might hold on the same given facts. Check that the expert's experience and qualifications are suitable for the case. The opinion of an orthopaedic surgeon in a paediatric case may not be relevant, or might be not as authoritative as that of a paediatric surgeon. Coroners and other parties recognise that inquests can be distressing for the families of the deceased. If you need a break at any time during the hearing, just ask for one. If you become upset, it will be difficult for you to focus on and remember the evidence being given. Much better to take 5 or 10 minutes out. At every inquest, there will be evidence in the form of a post-mortem report. Often the pathologist who wrote it will give evidence. Hearing about a post-mortem on a loved one can be particularly distressing. Often family members will want to leave the hearing room when the evidence is given and return afterwards. However, in some cases, the cause of death is not clear or the pathologist's evidence will be of particular significance. If you can't face asking questions to the pathologist, then put them in writing and give them to the coroner, asking him or her to put the questions on your behalf. I've already mentioned that interested parties are not allowed to address the coroner or a jury, for that matter, on issues of evidence, of fact. You can only make submissions to the coroner on the law. This includes suggesting the appropriate verdict. I mentioned the most likely verdicts earlier. A verdict may include a rider or additional finding that it was contributed to by neglect. I can't set out all the relevant law in this short film, but have a look at the guide produced by the organisation Inquest and you'll see what needs to be proved for certain verdicts to be returned. The verdict of suicide and the verdict of unlawful killing can only be given if the coroner is sure beyond reasonable doubt or is certain, so he or she is sure, that that is the correct verdict. A verdict of neglect is not the same as a finding of negligence. Neglect involves a serious failure to give nourishment or basic medical attention. A coroner can make a report to prevent future deaths, a so-called Rule 28 report. You may want to suggest in submissions to the coroner that there are steps that need to be taken, for example by the NHS Trust responsible for the hospital where the death occurred, to prevent future deaths. Invite the coroner to make a Rule 28 report and suggest the issues that the report should cover. I do hope you found this film helpful. Thank you for listening.